Hi, everyone, and welcome to the Adams and Reese Financial Services webinar series. I'm Amy Hanna-Keeney. I am the Financial Services Regulatory and Compliance Team Lead here at the firm, and I'm coming to you from beautiful Atlanta, Georgia today. I want to extend my sincerest welcome to today's program, which is going to be called Bankruptcy Basics, Commercial Landlords with Tenants in Bankruptcy. With me today, I'm very proud to present are my colleagues Josh Lesser, from our Houston office and Robert Parrott from our New Orleans office. Josh and Robert focus on commercial restructuring and bankruptcy in their practice, and they frequently counsel clients in the financial services sector. Before we get started, a couple of housekeeping items that we need to discuss. We want to hear from you today. If you have a question, we would love to hear it and be able to discuss it with you. That's why we're all here today. If you have any questions during the presentation, please type them into the question box on your control panel on your screen. Only our presenters will see the questions submitted, and we'll have time to address them at the end. We've specifically set aside some time to discuss those. Also, we're recording today's program, so we'll be sending you an email with a link so you can share the content with your colleagues or use it to reference in the future as well. Today's program has been pre-approved for 1 hour of CLE credit in 7 states. And we'll be submitting your attendance to those state bars if you indicated that you are registered or you're licensed in a specific state on your registration form for this webinar. Now, without further ado, I will turn it over to Josh.
Thank you, Amy. And as Amy told you, my name is Joshua Lesser. And thank you all for attending this Adams and Reese webinar on bankruptcy basics for commercial landlords. During this first segment, I will discuss the basics of bankruptcy for commercial landlords, touching on the fundamental topics, including the filing, the bankruptcy estate itself, the automatic stay, assumption and rejection of leases, the various types of claims a creditor such as a landlord may want to file to protect itself, and what rights a secured creditor has to collateral in the bankruptcy proceeding. So let's get started. The bankruptcy basics will cover questions such as what can the landlord do when the tenant files for bankruptcy and what shouldn't it do? What happens to the lease and how long does the tenant have to accept or reject? And what types of claims can the landlord file? So the first thing that we need to cover is the different types of bankruptcies that a commercial landlord might see its tenant file, Chapter 7 versus a Chapter 11. A Chapter 7 bankruptcy is a structured liquidation. When a debtor files or is involuntarily pushed into a Chapter 7 liquidation bankruptcy, a Chapter 7 trustee is appointed to step into the shoes of the landlord and to inventory and sell all of the, step into the shoes of the debtor and to inventory and sell all of the debtor's assets in order to pay the debtor's creditors. A Chapter 11 bankruptcy is a reorganization. When a debtor files or is involuntarily pushed into a Chapter 11 bankruptcy, it ordinarily continues operating as the debtor in possession and attempts to restructure its debts or to preserve or sell its business as a going concern. We will be discussing a Chapter 11 bankruptcy today from the standpoint of a landlord, which will generally be both a secured and an unsecured creditor to the bankruptcy. We will consider things such as whether the landlord wants to file a claim, what type of claims or claims the landlord will want to file, and what types of motions the landlord may want to file to protect its interests. So immediately upon the filing of a bankruptcy, all of the debtor's non-exempt property becomes property of the estate. This is governed by 11 U.S.C. 541. The use, sale, and lease of the property is governed by 11 U.S.C. 363. The debtor in possession does not have unfettered access to its own property. While generally it may use the property of the estate in the ordinary course of business, any use, sale, or lease of its property outside of the ordinary course of business needs approval of the bankruptcy court. And as we will see, if that property is encumbered by a lien, the debtor in possession needs to jump through additional hoops. Property of the estate is defined broadly under 11 U.S.C. 541 to include all legal or equitable interests of the debtor in property as of the commencement of the case. This does not include a commercial lease that has been terminated by its own terms, which is something to consider when drafting, for example, default termination, and automatic renewal provisions in a lease. For instance, a lease with a shorter automatic renewal period will be less likely to become and remain property of the estate. But of course, a landlord needs to weigh this interest against the interest to have a longer lease period for an at or above market lease with a paying tenant. The automatic stay. We've all heard of it, but what's it really about? Well, it's not just eviction. The automatic stay prohibits a lot of things. And for the purposes of a landlord, the automatic stay prohibits the commencement of a judicial, administrative, or other action or proceeding against the debtor, the enforcement against the debtor or property of the estate of a judgment, any act to exercise control over property of the estate, any act to create, perfect, or enforce any lien, any act to assess, recover a claim against the debtor, or any act to set off any debt against any claim against the debtor. So as you can see, it's pretty extensive. It doesn't just involve evictions, for example. So the automatic stay, as its name applies, is automatic. The stay goes into effect immediately upon the filing of a bankruptcy. No notice or hearing are required. Absent relief from the automatic stay, a landlord may not take any action outside of the bankruptcy case to collect, assess, or recover on a claim under a commercial lease that arose before the bankruptcy case, including the commencement or continuation of an eviction action or attempting to collect pre-petition rent. Resorting to self-help outside of the bankruptcy proceeding, such as even the filing for a statutory lien or the filing of a state court eviction lawsuit, can result in sanctions against the landlord. These sanctions may include actual costs and may even include punitive damages for a knowing violation under 11 U.S.C. 365H. The next thing we need to consider under the filing of a bankruptcy case is an ipso facto provision in a lease. An ipso facto provision is a lease provision that's triggered by the insolvency of the debtor, the filing of a bankruptcy, or the appointment of a trustee. These are generally not enforceable against a debtor in a bankruptcy case. For example, 11 U.S.C. 365 E1 provides that notwithstanding a provision in a lease, an executory contract or unexpired lease of the debtor may not be terminated or modified, and any right or obligation under such contract or lease may not be terminated or modified at any time after commencement of the case solely because of a provision in such contract or lease that is conditioned on the insolvency of the debtor, the commencement of a bankruptcy case, or the appointment of a trustee. So let's consider a hypothetical to demonstrate some of the points we've just covered with respect to property of the estate, the automatic stay, and ipso facto provisions. Say you have the following lease provision. In the event of an act of bankruptcy or by insolvency of tenant, or the appointment of a receiver for tenant, or a general assignment for the benefit of tenant's creditors, then the security deposit will be deemed immediately assigned to landlord. Would we run into problems with this type of provision in a bankruptcy case? What does everyone think? Does this clause affect property of the estate? Well, what does it affect? The security deposit. Now, how do we define property of the estate? That would be any legal or equitable right of the debtor. So would the security deposit fit that description? Likely yes. Would enforcement of the clause upon a filing for bankruptcy violate the automatic stay? Well, what would enforcement look like? It would be the security deposit being assigned to the landlord. Now, is that an act to control, exercise control over property of the estate? Likely yes. Is it an act to enforce a lien against property of the estate? Again, likely yes. Thus, enforcement of this provision would likely violate the automatic stay. Finally, is this an unenforceable ipso facto provision? What does everyone think? Well, Is it triggered by the bankruptcy, insolvency, or appointment of a receiver? It looks like yes, it is triggered upon the event of an act of bankruptcy or by insolvency or the appointment of a receiver. Does it modify or terminate the lease or any obligation under the lease? Inasmuch as it would modify the the tenant's right to the security deposit, then likely also yes. So therefore, this would probably be prohibited under the protections of 11 USC 365E1. So in conclusion, this provision would not likely be enforced in a bankruptcy case. Now keep in mind that this only applies to the enforcement of this clause against a debtor in a bankruptcy proceeding. But landlords should be careful when drafting provisions to avoid drafting a provision that would not be enforceable in bankruptcy when possible. The next thing we'll discuss is the assumption or rejection period. Upon the filing of a bankruptcy case, the debtor ordinarily has 120 days to decide whether it will assume or reject an unexpired lease of non-residential property, which we'll call a commercial lease. Commercial leases are afforded special protections under 11 USC 365. Now, under the 2021 Appropriations Act, this initial period was temporarily increased to 210 days after the filing for the tenant to assume or reject a commercial lease. This will expire on December 27, 2022 and revert back to the default 120 days we see in the bankruptcy code. The court may also grant a single 90-day extension for cause. Courts may not grant, however, an additional extension without written consent of the landlord. Now, pending assumption or rejection, the debtor must timely perform all commercial lease obligations. The landlord's collection of post-petition lease payments does not violate the automatic stay. However, and keep in mind, any proceeding to enforce collection would generally violate the stay unless it's brought in the bankruptcy case, and therefore it should be brought in the bankruptcy proceeding in the event the tenant is not, debtor tenant is not paying rent timely post-petition. So what if the tenant doesn't timely pay rent post-petition? Well, if the debtor fails to pay rent or otherwise perform under the commercial lease during the assumption and rejection period, the landlord may file, in addition to one of several claims we'll discuss immediately after this, various motions, such as a motion to enforce rent or a motion to compel assumption or rejection of the lease. The bankruptcy court may delay the tenant's performance of any lease obligations during the first 60 days of the bankruptcy case. Keep that in mind. Recently, courts have been granting this type of extension solely due to the COVID-19 pandemic. So it's something that landlord with a tenant who has talked about bankruptcy or something of the like to keep in mind. Now, Congress recently passed the Small Business Debtor Reorganizations Act, which is a subsection, subchapter 5 of chapter 11, which applies to certain small businesses. While the entirety of the Small Business Reorganization Act is beyond the scope of this presentation, it is important to keep in mind that there are special rules that apply to these cases. For example, the 60 days for which a court can extend the obligations of the lease during the assumption rejection period is automatically 120 days under a subchapter 5 case. Next, we'll discuss the types of claims a landlord should consider filing. Claims can be either administrative, secured, or unsecured. Administrative expense claims are paid first and must be paid in full before any other types of claims are paid. These are generally paid 100 cents on the dollar unless the bankruptcy proceeding is administratively insolvent. Post-petition lease arrearages, these are the rents that arise after the bankruptcy case is filed, give rise to an administrative expense claim calculated as the fair market value of the debtor's use and occupancy of the lease. Now, there's an initial presumption that rent as stated in the lease is fair market value. However, the debtor tenant may overcome that presumption upon evidence that the lease is over market, in which case the administrative expense claim that the debtor would be entitled to would solely be for that fair market value rent, and then the balance of that rent and then the rent under the lease would become an unsecured claim, which we'll discuss in a minute. Like I've mentioned, if the debtor tenant fails to timely pay rent pending its assumption of rejection, the landlord has various types of motions it can file, including a motion for an administrative expense claim pursuant to 11 U.S.C. 503. And that's to keep in mind that if the tenant is timely paying rent post-petition, there's no need to file a claim for those rents because they're getting paid. Security interests, collateral. Security interests are generally not stripped in bankruptcy absent special circumstances. Finally, unsecured claims are paid last under the absolute priority rule, generally subject to a heavy discount if they're paid at all. Pre-petition lease arrearages, those are arrears that had accrued prior to the filing of bankruptcy, give rise to an unsecured claim. And any undersecured portion of an otherwise secured claim, i.e. any amount in the note that's not, any amount in the note that's not covered by the value of the collateral is treated as an unsecured claim. Finally, as part of this first section, we'll discuss the all-important topic of collateral. Now, often a landlord will take a security interest in property of the tenant. This is, of course, in addition to a security deposit, which is generally collateralized against rents. Now, whether a creditor, in this case a landlord, is under or oversecured is something that's important to consider because it'll lead to different protections. If a creditor is undersecured, it may seek adequate protection during the pendency of the bankruptcy case to protect security interest as of the date of the filing, and we'll discuss adequate protection briefly in a minute. If a debtor is oversecured, it is entitled to interest on such secured claims and any reasonable fees, costs, or other charges provided for under the agreement or state statute under which such claim arose. And we'll discuss this briefly in just a second on the next slide. Secured creditors also have an automatic super priority claim, and super priority just means it's ahead of administrative expenses, which is rare. Usually administrative expenses are first. To the extent it becomes undersecured due to diminution in the collateral during the pendency of the bankruptcy case. That's just its own rule. Now, recall a secured creditor is generally entitled to adequate protection. Adequate protection may include single or periodic cash payments to the extent the stay, use, sale, lease, or grant of a lien on the collateral results in a decrease in value. Replacement liens or additional liens to the same extent. Such other relief, which is not limited to but may include inspection of the debtor's books, payment of the creditor's legal fees, granting of equity in the reorganized debtor to the creditor, or access to non-debtor assets. And a subordination agreement as between two secured creditors entered into pre or post-petition is enforceable under the bankruptcy code. Now, this is one of the rare types of ipso facto provisions that is enforceable. Such an intercreditor agreement may leave junior or 2L secured creditors unable to challenge a 1L or secured creditor with greater priority, unable to challenge such 1L creditors' adequate protection payments, unable to receive certain forms of adequate protection, such as cash payments themselves, may agree to the priority of liens, i.e. to subordinate their liens, and agree to support a plan of reorganization. This is common in a pre-pack or prepackaged filing where the secured creditors have already agreed to everything and entered into agreements to that effect. So fights over adequate protection primarily arise in two contexts in Chapter 11 bankruptcy cases. First is the debtor's use of cash collateral over which the creditor has security interest. Now, this is important for landlords because, as I'm sure we've all seen and I said earlier, landlords will often, in a commercial lease, take a security interest over receivables of the tenant debtor. Cash collateral under the bankruptcy code is defined to include cash equivalents, and other collateral liquidated during the bankruptcy. The debtor with a debtor with a security interest in cash also has the right to adequate protection, which we discussed just a moment ago. The second context in which a fight over adequate protection will arise is the debtor's request to obtain DIP, or debtor in possession financing. DIP financing acts as the capital infusion necessary to successfully reorganize. Priming liens may be granted to secure DIP financing only if the secured creditor who's primed is adequately protected. Litigation may arise over whether such primed creditor is adequately protected. Additionally, pre-petition liens can be rolled up and prime all previously priming liens. Now, this is done in order to incentivize a DIP lender to bring new money to the table and finance the bankruptcy itself, and then provide that capital infusion. So it'll generally, if there is a roll-up, be a combination of new money and rolled up priming liens. So I have one last hypothetical as part of this section, and it's about the recovery of fees, which the recovery of fees in the context of a secured creditor and adequate protection. So let's say you're an oversecured creditor, and recall an oversecured creditor is entitled to reasonable fees, costs, or other charges provided for under the agreement. Now, it's important to keep in mind that the agreement has to provide those fees. Which of the following lease provisions would you prefer to rely on? Upon the filing of bankruptcy by tenant, tenant shall be liable to landlord for all costs and reasonable and necessary attorney's fees. What do we think about this one? Well, it looks a lot like an ipso facto provision, so let's see if we can do any better. In the event of a default, landlord shall be entitled to recover all court costs and reasonable and necessary attorney's fees from tenant, including incurred in collecting rent or otherwise enforcing landlord's rights under this lease. This looks better, and we'll discuss in just a sec here, but we need to make sure that there's an event of default that doesn't run into ipso facto trouble. Finally, we have the prevailing party in any legal proceeding based upon this lease shall be entitled to reasonable attorney's fees and expenses and court costs. Now, this looks better, and I think it's the least likely to run into automatic stay or ipso facto provision issues, but of course it requires the party to prevail. So it's not perfect, but it's definitely the least likely to be held unenforceable in a bankruptcy case. Now, be mindful that relying on the bankruptcy, insolvency, or appointment of a receiver as the event of default may be challenged as an unenforceable ipso facto provision, which the debtor successfully did in this one case, where they were awarded $0 under a fee shifting provision in their lease because their only event of default was the bankruptcy itself. No fun. And that does it for this first section on the basics. If you have any questions, again, please let us know in the chat, or don't hesitate to shoot me or Robert an email. And I'll now pass the presentation off to my partner and co-presenter, Robert Parrott. Thank you.
Good afternoon, everyone. My name is Robert Parrott. I'm an attorney in Adams and Reese's New Orleans office. In the second half of this presentation, I'm going to go into a little bit more detail on the topics of assumption and rejection. We'll discuss what the tenant's required to do and what the landlord's entitled to in the case of assumption or rejection of the lease. I'll also discuss some special topics, including issues relating to letters of credit and guarantees, and then we'll field any questions that the attendees may have. So a couple of things, and Josh briefly went over some of this in his presentation. The debtor has the option to assume and assign, or reject an unexpired lease. And the debtor has 210 days to make that decision. Ordinarily, that time period is 120 days, but as Josh mentioned, under the 2021 Consolidated Appropriations Act, that 120-day period has temporarily been extended to 210 days, and that will expire, and the period will revert back to 120 days on December 27th, 2022. If the debtor does not make the decision to assume and assign the lease within that period, it's deemed automatically rejected at the expiration of that time, and the debtor must vacate the premises. As Josh mentioned, pending assumption and rejection, a debtor must timely perform all of its all of its obligations under the lease. During this time and prior to bankruptcy, it's common for landlords and tenants to attempt to renegotiate the terms of a lease, the curing of any arrears or any other issues pertaining to the tenant's use and occupancy. And the landlord, in most cases, should have some sense of what the debtor's intention with respect to the lease will be, either pre-bankruptcy or during the time within which the debtor has to decide whether it will assume or reject the lease. And discussions are typically ongoing during that time period. Pending assumption or rejection, the landlord will want to make sure its claim is properly scheduled and or file a proof of claim. We always recommend filing a proof of claim regardless of whether the claim appears to be properly scheduled in the debtor's schedules, just to avoid any waiver type of argument. And the court will typically issue a scheduling order. It's ordinarily called a bar date order, and it sets the deadlines for the filings of proofs of claim and also for things, for example, motions for administrative expenses. This next slide, we're going to go into a little bit more detail on what is required of the tenant. But first, I want to note a very important aspect of the bankruptcy code. The bankruptcy code permits an assignment of a lease to a third party, even if there's a provision in the lease that prohibits assignment. And it's very common for commercial leases to have these types of anti-assignment clauses in them. But pursuant to Section 365F of the bankruptcy code, that section expressly permits assumption and assignment of a lease, notwithstanding any provision in the lease or under applicable law. On a related note, a number of courts have held that a profit sharing upon assignment clause is an unenforceable restriction on assignment. The rationale that those courts underlying those courts' decisions is that Section 365F was designed to prevent anti-alienation or other clauses in leases assumed by the debtor from defeating the debtor's ability to realize the full value of its assets in bankruptcy, and a clause that provides that the landlord will profit share with the assignee upon the assignment is a hindrance on the debtor's ability to fully realize the value of its assets. So what is a tenant required to do in order to assume a lease or assume and assign a lease? Well, first, the tenant must cure virtually all types of outstanding defaults under the lease or provide adequate assurance that it will do so. The tenant must also provide compensation for any actual pecuniary losses resulting from such defaults or provide adequate assurance that it will do so. And lastly, the tenant is required to provide adequate assurance of future performance under the lease on a going forward basis. In the case of an assumption and assignment, the landlord's entitled to adequate assurance of the third party assignee's future performance on a going forward basis. Adequate assurance is a bankruptcy term, and it can take many different forms. It may require the tenant to show that its reorganization or debt restructuring will enable it to have sufficient cash flow to pay its landlord. If the debtor tenant's projections suggest that making payments will be a close call, the landlord may seek to demand additional protection, such as an affiliate guarantee or an additional security deposit. This next slide, I want to just go over some ancillary issues related to assumption that I think are important to point out. First, if the tenant decides to assume the lease, it must assume the entire lease. And the corollary to this rule is that if a tenant decides to reject its lease, it must reject the entire lease. Now, of course, the landlord and the tenant may agree to modify the terms of the lease but ultimately the modification is subject to bankruptcy court approval. So to the extent a landlord and tenant agree to modify the terms of the lease, the tenant must then request bankruptcy court approval to assume the lease as modified by the parties' agreement. The circumstances in which a tenant may assume and assign the lease typically arise when the lease is part of a sale of the tenant's assets to a third party, or when the rental rate under the lease is below market. Of course, the debtor must provide the landlord notice of its intent to assume and assign the lease, and it typically does so either in a standalone motion to assume the lease filed in the bankruptcy proceeding, or it could be encompassed in the debtor's proposed plan of reorganization. Whether it's either approach, the landlord will have a limited time to file a written objection. And an example of the types of objections a landlord may have are an objection to the proposed cure amount if the landlord's calculation of the cure amount is greater than the tenant's calculation, or on the basis that the tenant or the proposed third-party assignee is unable to provide adequate assurance of future performance. It should be noted that while a landlord can object, ultimately the tenant does not need to obtain the landlord's consent. All the tenant needs to do is obtain bankruptcy court approval over any objection the landlord may have. Now, on a related note, when it comes to opposing a motion to assume, landlords should be aware that some bankruptcy courts have awarded debtors the fees incurred in overcoming a landlord's objection to the assumption of a lease under certain circumstances where there's a fee shifting clause in the lease. And in fact, there was a recent opinion just 2 weeks ago, February 19th, 2021, out of the United States Bankruptcy Court for the Central District of California, in which the bankruptcy court awarded a debtor $606,000 in reimbursement for attorney's fees the debtor had incurred in overcoming the landlord's opposition to the assumption of the lease. And in that case, prior to the bankruptcy filing, the landlord had served a notice of default and a 3-day notice to cure on the tenant. The debtor tenant responded by filing bankruptcy and followed subsequently with a motion to assume the lease, which the landlord opposed on the basis that the lease was in default. After a 5-day trial, the bankruptcy judge ruled in favor of the debtor and allowed assumption and found that the debtor had not breached the lease. Subsequently, the debtor requested $606,000 in the attorney's fees it had incurred in the proceeding and overcoming the landlord's opposition, and the court awarded the debtor that request. That case is In Re Hawkeye Entertainment LLC, and that's case 19-12102 in the Central District of California Bankruptcy Court. Lastly, it should just be noted for shopping center landlords, there are additional protections for shopping center landlords, particularly when it comes to assumption and assignment of the lease. In that context, recall that in order to assume a lease or assume and assign a lease, the tenant must cure all defaults and provide adequate assurance of future performance. In the context of shopping centers, adequate assurance has additional requirements. I'm not going to list them all, but for example, one of the requirements in order to provide that adequate assurance is the tenant must show that, or the tenant and or third-party assignee must show that the assignee's proposed use of the lease premises will not disrupt any tenant mix or balance in the shopping center. Okay, so we can move to the next slide, Josh, please. We're going to talk about rejection now. A rejection is treated as a breach immediately prior to the bankruptcy filing. Upon rejection, the lease is immediately terminated and the landlord has a rejection damages claim. And a landlord is generally required to file a proof of claim in the bankruptcy court to assert rejection damages. In the case of a rejection, the landlord may assert, and Josh, can you please follow up on those bullet points? Yes, great, thanks. In the case of rejection, the landlord may assert for its rejection damages claim a general unsecured claim for damages arising out of the rejection. This includes lost post-petition rent, the cost of reletting the premises, and attorney's fees, all to the extent that those amounts are specifically provided for under the lease. Now, as Josh mentioned, the landlord will also have an administrative expense claim for unpaid post-petition rent for just the period between the bankruptcy filing date and the rejection date. Now, a landlord's rejection damages claim is capped pursuant to the bankruptcy code, and it's capped at the greater of 1 year's rent or 15% of the rent due under the lease, not to exceed 3 years' rent. This cap is intended to compensate the landlord for the loss associated with termination of the lease, while at the same time preventing the lease termination claim from overwhelming the pool of general unsecured claims. And as we will discuss here in a moment, a favored method of trying to avoid the cap is to require the tenant to obtain a standby letter of credit upon which the landlord may draw if the tenant defaults. And we'll discuss that actually now on the next slide. So there are several ways for landlords to obtain credit support to reduce the risk of the tenant defaulting, under the lease. One method, as Josh hit on in his half of the presentation, is a traditional cash security deposit. However, because traditional cash security deposits are normally deemed to be property of the tenant's bankruptcy estate, even though the landlord holds the money, it's not the best credit support mechanism from a bankruptcy perspective. The reason being, the landlord will only be able to set off the deposit against unpaid amounts due under the lease only after it obtains relief from the automatic stay, or if the tenant's Chapter 11 plan permits it. This inherent delay in applying the deposit can harm a landlord, particularly a landlord that relies on regular rent payments from its tenants in order to meet its own mortgage obligations on the property. If the amount of the security deposit exceeds the landlord's capped claim amount, the tenant must turn over the excess. So an example, let's say there is a landlord who has suffered actual damages due to termination in the amount of $1 million. But under the rejection damages cap, the claim is capped at $500,000. The landlord also holds a security deposit of $750,000. In that situation, the landlord has a secured claim against the tenant for $500,000 up to the cap, but the landlord must return the remaining $250,000 to the bankruptcy estate due to the cap. Another form of common credit support is a letter of credit, which the tenant would obtain from a third-party issuer, typically a bank. As a general rule, letters of credit are not affected by the tenant's bankruptcy filing. The letter of credit in this situation will typically provide that the third-party issuer will pay the landlord directly upon demand, with the landlord being able to make demand if the contractual obligation or the contractual conditions to payment under the letter of credit are met. For example, the tenant's payment default under the lease would trigger a condition for payment under the letter of credit. Because of what's called the independence principle inherent in letter of credit law, which provides that a letter of credit is an independent contractual obligation of the issuer, the automatic stay in the tenant's bankruptcy case does not prevent the landlord from drawing on the letter of credit so long as the lease and the letter of credit don't obligate the landlord to take any action vis-a-vis the tenant, such as it could be as minor as providing notice to the tenant. As a result, landlords are well advised to obtain a letter of credit instead of or in addition to a cash security deposit, and also to ensure that the terms of the lease and the letter of credit don't obligate the landlord to take any action vis-a-vis the tenant before being able to draw on the letter of credit. Lastly, another form of credit support is a guarantee by either an entity that is affiliated with the tenant or one or more principals of the tenant. If the tenant files bankruptcy, but the guarantor does not, in most cases, the landlord will be free to collect on the guarantee without ever having to step foot in bankruptcy court. This is because the automatic stay generally only applies to the specific entity or individual that has filed bankruptcy. However, under a few circumstances, a tenant will be able to obtain a bankruptcy court order extending the stay to affiliates and principals that haven't filed bankruptcy, but courts that do that typically only do so under very unusual and extraordinary circumstances. And of course, if the guarantor itself has filed a separate bankruptcy, the automatic stay in the guarantor's own bankruptcy will halt the landlord's efforts to collect on the guarantee. The last bullet point here on this slide, I want to particularly emphasize, and it plays a role in a strategic decision that the landlord will have to decide if it appears that the proceeds it could realize by drawing on a letter of credit exceed what its rejections damages would be capped at. The issue is particularly highlighted in a Fifth Circuit case in the Stonebridge Technologies Inc. bankruptcy. This is a 2005 opinion. In that case, to secure the obligations under its lease, the debtor provided the landlord with a security deposit and a letter of credit. After the debtor filed bankruptcy and rejected the lease, the landlord drew down on the letter of credit but never filed a proof of claim. The liquidating trustee sued the landlord for improperly drawing on the letter of credit and for retaining the proceeds in excess of the rejection damages cap. The bankruptcy court held in favor of the liquidating trustee and ordered the landlord to return the letter of credit proceeds that exceeded the cap. However, the Fifth Circuit Court of Appeals reversed, holding that by its terms, the rejection damages cap in the bankruptcy code only applies in the event the landlord files a claim against the estate. According to the Fifth Circuit, the landlord had no need to file a proof of claim because the amount of the security deposit and the letter of credit exceeded the amount of the landlord's claim as capped by the bankruptcy code. And thus, the court reasoned since the landlord did not file a proof of claim, the rejection damages cap was not invoked, and the landlord was not prohibited from drawing the full amount of the letter of credit to apply the proceeds against unpaid lease damages, even those in excess of the cap. Now, this is still an undecided case in many jurisdictions. This is a Fifth Circuit case, which encompasses Texas, Louisiana, and Mississippi. But the lesson for this case, particularly in the Fifth Circuit, is that for a landlord that has letter of credit proceeds in excess of the amount of the claim cap, the lesson is to not file a proof of claim. Thus, you will not invoke the rejection damages cap under the bankruptcy code, and you may be able to retain proceeds in excess of the cap. Just lastly, a few notes with respect to letters of credit. Landlords may be well advised to include certain provisions in the lease regarding to protect themselves with respect to the letter of credit. Those provisions include giving the landlord the right to approve the bank issuing the letter of credit, the right to demand a replacement letter of credit if the financial condition of the issuer deteriorates based on certain criteria, and a provision that if the issuing bank is placed into FDIC receivership and fails, that the landlord has the right to demand that the tenant replace the letter of credit with a new letter of credit subject to the landlord's approval. Next, we'll cover attorney's fees just briefly. It should be noted that landlords may be able to recover attorney's fees when a debtor assumes and assigns a lease. And in order to do so, the criteria outlined in the bankruptcy code are as follows, and they're listed here on the slide. First, the lease must expressly provide that the landlord is entitled to recover attorney's fees above and beyond rent. Josh, can you move us forward? Thank you. And then the second requirement is that the landlord must have prevailed in the proceeding in which it seeks to recover attorney's fees. For example, the types of proceedings which may qualify would include an objection to the proposed cure amount, a motion for adequate assurance, or a motion to declare a default and for damages. Third, the legal right must derive from the lease and independently from state law or the bankruptcy code. And lastly, the attorney's fees must be reasonable, and the court will consider various factors regarding the reasonableness of the fees. Our last mini special rule topic to cover is adversary proceedings. Under the federal rules of bankruptcy procedure, any issue arising in the context of the main bankruptcy case, which bears on a contested request for relief, is a contested matter. And contested matters can be heard and decided either in a motion filed in the main bankruptcy proceeding or in a separate adversary proceeding, which is a proceeding in the bankruptcy court, but it's initiated by the filing of a complaint typical to a standard lawsuit, and it's assigned its own case number. And largely adversary proceedings they proceed like a federal court case would proceed. There's a discovery period, and they're largely governed by the federal rules of civil procedure as made applicable through the bankruptcy or the federal rules of bankruptcy procedure. Federal Rule of Bankruptcy Procedure 7001 provides that there are certain contested matters that must be brought as adversary proceedings. Otherwise, whether to bring a claim as a contested matter through a motion in the bankruptcy case or an adversary proceeding depends on various factors such as the amount of discovery and time that will be required. That concludes my half of the presentation. We'll now field any questions that we may have received. I'll let Amy chime in and let us know if we have any questions.
Hi, everyone. I'm back. Thank you, Josh and Robert. That was fascinating. We have quite a few questions, so if you guys are ready, I'm just going to go ahead and start reading out some questions. You guys ready?
Ready.
Sounds good.
Great. Okay, first question we've got. I think this one is going to be directed to you, Josh. Is there any difference between the types of liens a landlord may hold?
So yes, that's a really good question, actually. And in the world of bankruptcy, all liens are not created equal. Specifically, 11 U.S.C. 554 provides that the trustee may avoid certain types of liens, which include statutory liens, as opposed to contractual liens, which they may not avoid, as well as liens for rent or unperfected liens. So this is really important to consider for a landlord when it's looking to rely on a lien to secure its rent. They would prefer to have a contractual lien in that instance.
Okay, thank you. I think this one is pretty related to this question, so I'll field this to you, or I'll let you field this, Josh. If the right to file a lien arose under contract pre-petition, for example, a landlord's lien provision in the lease, would filing the lien post-petition violate the stay?
So yes, if you have the right to a contractual lien pre-petition, but you have not filed or perfected that lien, it would violate the automatic stay to file or perfect that lien post-petition. These are types of actions against the property of the estate or the debtor that we saw are prohibited under the automatic stay.
Okay, thank you. Third question we have, I think, is also directed to you, Josh, so you're still on the hot seat. In the first hypo you gave, with the assignment of the security deposit to the landlord, what if the security deposit is in the possession of the landlord? Is it still part of the property of the tenant's estate?
Sure, so that's also a good question. The answer is yes. Just because it's in the possession of the landlord doesn't change the fact that it is property of the estate. There's even provisions in the bankruptcy code for turnover of property of the landlord, turnover of property of the debtor to the estate, the trustee or the debtor in possession, what have you. And there was a recent United States Supreme Court case that held, though, that simply holding property of the estate does not violate the automatic stay unless and until the debtor in possession or trustee files a such a turnover motion against the person in possession of that property. Good question. Thank you.
Good. Okay. Okay, I think this question is directed to you, Robert. So Josh, you're off the hot seat for now. If the debtor tenant has subleased some or all of the premises to a subtenant and rejects the prime lease with the landlord, would the subtenant have the right to remain on the premises?
Okay, that's a good question. So obviously it's clear that the debtor tenant, so the question is, if the debtor tenant rejects the prime lease with the landlord, would the subtenant, if there is one, have the right to remain on the premises? Clearly the debtor tenant would be required to vacate the premises, but I don't think it's entirely clear whether any subtenants would be required to vacate the property. There are certain subsections in section 365 of the Bankruptcy Code which protect certain rights of tenants if the landlord were to file bankruptcy, and those sections may be construed to give subtenants the right to remain on the property, or at least be able to raise any available rights under state law even after the debtor tenant rejects the prime lease. I believe a number of courts have held that those sections don't protect subtenants who don't have a direct agreement with the landlord. And the reason for that is that subleases depend on the continuing viability of the prime lease, and the rejection of the prime lease also results in the rejection of the subleases. However, a landlord might still have to litigate this issue with subtenants in jurisdictions where the issue has not been settled.
Okay. I think that's all we've got for questions. So thank you both very much. And thank you everybody for attending. We'd like to thank you all for allowing us to present this program to you today and for spending this hour of your day with us. As a reminder, we recorded this session today and we're going to send you an email and a link with the recording of the presentation so you can share that with your colleagues or keep that for reference. And we're also going to send you a certificate of attendance for CLE credit. In closing, we'd like to mention that our firm has produced numerous COVID-19 related resources on our firm's website, which is adamsandreese.com. Content is accessible from the homepage, is organized by subject, including, importantly, financial services, relief assistance guidance, cybersecurity, employment, and business law, and government investigations. Updates can also be found following the firm's pages on various social media, such as LinkedIn, Twitter, Facebook, and YouTube. Thanks again, everyone, and I hope you have a wonderful afternoon.
Thanks, guys.